Graduate route visas refused for breach of conditions while on the student permission. So this is quite a common problem that I have seen. Many of these graduate route visas or permissions applications are refused if the Home Office becomes aware that in any time during your student period, your student leave period, student permission period, you have breached the conditions of that permission, which means usually I've seen it is for work related conditions. You are only allowed 20 hours of work during term time. In that case, if you work more than the 20 hours and Home Office becomes aware of this, they will refuse your graduate route leave. So this is a common occurrence I have seen many times. I have seen several refusals also on these when clients send this, when they file these applications themselves. So you cannot do anything about this. That is the first point. If you have got this refusal, Home Office always has some evidence against you. They would usually have your national insurance. They may have run through the HMRC data. They've seen a PAY real-time reporting, which the employers are required to do. Usually this is quite common with care homes. I've seen many of these care homes are getting audited for sponsor license or for defined causes or whatever they have done. Care homes are for the senior care worker job codes. Currently it is I think 6135 or something, whatever. 6135 and 6136, those are the two job codes currently for care workers, I think. So, and previously they were 6145 and 6146. So for these job codes, the graduate route holder or the student visa holder may not be anywhere related to this, but they may be just working part-time with a care home. They may not even be sponsored by that employer. So, but for some breaches of the employer, or for whatever reason the employer has been audited, usually care homes or even any other employers may be audited, and in that audit, if it comes to light, obviously they will check all the migrants records as well. Usually they will see how many migrants you have employed. Are you meeting all the immigration rules for those migrants? So definitely they are trying to see all the breaches of any compliance or any immigration laws broken by the employer. That is a bigger thing that they are looking at. They're trying to catch the bigger fish, but in that the small fish also get caught. So usually, which is the student permission holder, if you have worked whatever, let's say 30 hours a week or something, even once, and if they find that out, they have the option of refusing your graduate route, the next permission, on the basis that on the previous permission that we had granted you, we had told you the compliance requirements. However, you broke those. You are in breach of your compliances for the student permission. So it is a common refusal. I've seen that. So this is my wise advice to students coming to the UK to study. Make sure you keep within your limits. Work 20 hours only during term time. That is very important. Out of term time, anyways, you can work full time. But while you are in your term time, don't exceed the limits. Even if the employer says that you have to work more, you may have to tell the employer that sorry, I cannot work for you for more than these 20 hours that I am allowed to work, or I would breach my conditions of my permission. I know many times employers may not realize this. It may be a small employer, it may be an individual or whoever that is. It will not have that much of an impact on the employer because they may never apply for a sponsor license, but this may get, usually through sponsor license audits and all, or applications for sponsor license, these things do, they do surface. But it may come up anytime. Once you apply for a graduate route leave, Home Office caseworker may just do your NI, run on your NI number, and they may find some information on it. They may query the employer, they may go forward, and they may ask you information about your pay slips or anything like that. So it is always suggested, and this is my wise and best advice, nothing can be done if something has been already done. You already broken the rules. You cannot do anything about it. If you are in breach, you are in breach. There is nothing to undo it. You may send any evidence of mitigating circumstances, or I was not aware of this, or my employer forced me to do this. I don't think that would stand much ground in the eyes of Home Office, and that may not help your case, because usually the Home Office doesn't even give you that opportunity. Anytime I've seen all these PSW graduate route refusals, the Home Office straight away sends you a refusal letter and gives you all the evidence saying we have seen all these records with this particular employer, we have seen these pay slips or these your NI records, everything. They will just detail it, and they would have already done the homework. So there is no argument to that. They will have all the evidence against you. Without that, they are not going to refuse it. So remember that. Don't breach your conditions, especially work conditions. This is a very common thing. The work conditions, students tend to tend to break it. In the past, it was not a very serious matter. I have seen home office would not matter much, but then would not care much. But recently, I have seen this last 1 year or since the graduate started usually. And nowadays it's very, very common that they may do your NIRN, and if they find that you have been working, it may not be very straightforward, but they will do their investigations and find it out. If yeah, they have their own way of researching it, get information from the employer or however from HMRC and all. But if you have done that, I don't think there is much that you can undo. But if you are already in breach and you are trying to do it, you should definitely stop it. This may be a mitigating circumstance. For example, you watch this video and you stop, you told your employer and you stop doing it. It may be a mitigating circumstance, but I'm not sure whether it will help. But definitely, if you have been working over the allowed 20 hours, please do stop doing that. And yeah, have that case and information with you. Maybe in future it may help you. So if you already worked more than 20 hours, it may not help you. But then for any future students or any students who are considering working, or they are confused whether they should work more than 20 or not, I would strongly advise against working more than 20 hours if you are only allowed 20 hours. And yeah, this is my wise advice. That's why I'm just making this video, because I know these refusals come to me after everything is done, and at that point a lawyer cannot do much, frankly speaking. I know other lawyers may charge you, they may start writing to home office, but at the end of the day you may not get much. These are not human rights based applications. You don't have much recourse over here. There are no appeal rights. They only go for an admin review pending. Waiting period is about 12 months or so. And even after that, what is an admin review? Just if I am the case worker, my friend, my colleague sitting next to me who will do the admin review. So we don't expect much results from an admin review, that too after waiting for 12 months or so. So it's better, it's to take a preventative measure and take the precautions and work only under your conditions of work, 20 hours only, while you're on your student leave. So this, I'm just making this video to just alert everyone, as nothing can be done at the end once everything has been, like, you messed up the situation. So just want to give this wise advice. If it helps you, do like this video, subscribe to our channel, and maybe become a paid member or paid subscriber on TikTok or YouTube and support our channel. And if you don't like this video, definitely give a dislike it twice and make your point, and I will refrain from making such videos if there are enough dislikes. Thank you very much.